Capital Territory, Abuja, is to be treated as one of these in the calculation of 2/3 of the states of federation. Thus, that if the candidate falls 25% or 1/4 of votes in 2/3 of 37 states of the federation, FCT Abuja inclusive, the presidential candidate shall be deemed to have been duly elected, even if he fails to score 25% of the votes cast in the Federal Capital Territory, Abuja, as the second respondent did. In conclusion, I hold without any equivocation that in a presidential election, polling 1/4 or 25% of total votes cast in the Federal Capital Territory is not a separate precondition for a candidate to be deemed as duly elected under Section 134 of the Constitution. In consequence, Issue 4 is also resolved against the petitioners and in favor of the respondents. It is right, Lord, that there is a rebuttable presumption of regularity with respect to election results, and it is for a petitioner who challenges that result to rebut that presumption with credible evidence. This settled principle was stated by the Supreme Court in Buhari and Ane, and Mesom and Peter cite others. Also in Udom Gabriel Emmanuel versus Umana Okon Umana and others. All citations supplied. I have also referred to Abubakar and Eradua, Louis versus Anik, Ikiriko, Duluma. From the foregoing, it is clearly evident that the petitioners have failed to discharge the burden of proof placed on them by law. They have failed to prove any of the three grounds contained in paragraph 20 of this petition. They have not been able to lead any cogent, credible, and acceptable about the legal presumption of correctness of the result of presidential election held on 25th February 2023, led by the first respondent. Having resolved all four issues in this petition against the petitioners, this petition is clearly unmeritorious. As I stated earlier, it's a consolidated petition. So when we examine that of petition number 4, our learned brothers state their own position. And number 5, sorry.